Good afternoon and welcome to the New Civil Liberties Alliance Lunch and Law. Today's program is entitled, "This is what a win looks like. The Supreme Court confirms the right to challenge agencies in court." And here today to discuss the decision in FTC, or Axon v. FTC and SEC v. Cochran, we have two individuals who have been extremely involved with the Cochran case for quite a long time. First of all, we have the former Solicitor General of the United States, Garre, with us. Greg argued the SEC v. Cochran case at the U.S. Supreme Court last November. He is the partner at Latham Watkins and the head of the Supreme Court practice there. Greg attended Dartmouth College and George Washington University Law School, where he was the editor-in-chief of the Law Review. He then clerked for Judge Anthony Sirica on the Third Circuit Court of Appeals and for Chief Justice Rehnquist at the Supreme Court. He then, in addition to being the former Solicitor General, he's the former Principal Deputy Solicitor General and Assistant Solicitor General, and I'm told the only person who's ever held all three of those posts in the Solicitor General's office. Just can't get enough of arguing in front of the Supreme Court. Exactly. We're also joined by Senior Litigation Counsel Peggy Little, our first litigator ever hired here at NCLA, and someone who was here on the day that Michelle Cochran walked into the office, has been on this case from day one, and argued it in the Fifth Circuit and in front of the en banc Fifth Circuit, and the stay that we won from the Fifth Circuit as well. So I couldn't have two people who know this case better. Delighted to have you both. So I don't want to spend a lot of time talking about this case. In part, for the audience watching at home, we had a program about this case last year with Michelle Cochran on the stage with us. If you want to hear the background of the case and learn more about her story, I would invite you to go back and watch that prior Lunch and Law. Today, we're going to focus on the decision in SEC v. Cochran, what the meaning of that is, and ramifications for the future. And so maybe to begin, I'll just say maybe 30 more seconds about the case, and then jump right into questions. The decision, as the title of today's program suggests, is that individuals like Michelle Cochran, who are in enforcement actions or the targets of enforcement actions by agencies like the SEC, formerly they had to go all the way through the administrative process before they could raise constitutional objections to that process, to the agency, to the administrative law judges that they were in front of. Now, as a result of this decision, they'll be able to go directly to federal district court. The Supreme Court has decided there is subject matter jurisdiction in federal district court to hear those sorts of constitutional objections to the tribunal. You don't have to spend 4, 5, 6, 7 years in an administrative process before you can get in front of an Article III judge to raise those constitutional concerns. I think this is a game-changing decision from the Supreme Court. And maybe I'll start, Greg, with you. And this was a unanimous decision from Justice Kagan, 9-0. Why did so many lower courts get it wrong? I mean, usually you think of the tough cases making it to the Supreme Court, but they said 9-0.
Yeah, that's right. And that's kind of the scary thing about this case, is that so many lower courts had gotten it so wrong for so long. I mean, we had, I think, maybe like 5 circuits who had addressed this issue starting in 2015. All of them applying the judge-made Thunder Basin factors had concluded that the SEC statute and the FTC statute had impliedly stripped district courts of their jurisdiction to hear these structural constitutional claims. There were a few smart and brave dissenters along the way, Judge Droney from the Second Circuit, Judge Bumatai in the Ninth Circuit, and Judge Haynes in the Fifth Circuit. But everyone else got it completely wrong until Peggy convinced the Fifth Circuit to get it right and created the conflict that is the reason why the Supreme Court got involved, which was, probably the most important step in this whole process. And, I think the real problem, I think the reason is twofold, ultimately, to answer your question, Mark. One is the murkiness of the Thunder Basin factors themselves, which lend itself to manipulation. And two is, I think that for most of this time, courts were operating with, perhaps a thumb on the scale for administrative proceedings like this. And I think that latter point has really fundamentally changed. And I think,
as a result of this decision?
I think
in part.
Leading up to this decision, there's been a change in perception about the dangers of administrative adjudications and administrative state more generally. And I think that the decision is resounding evidence of that, in that, not to get ahead of things, but
Sure.
that it was, unanimous. That Justice Thomas went even further, as he often does, in sort of proclaiming some of the harms here. I know we'll talk about that later. And that Justice Gorsuch, really went out of its way to excoriate the agency for its conduct in these proceedings. So that's a long answer, but that's kind of the way I see it.
Yeah. Peggy, what's your view on that? I know there were some district judges along the way who did the right thing and were promptly reversed by courts of appeals. But you looked at a lot of these lower court cases when you were trying to convince the Fifth Circuit to go the other way. Why do you think so many of them got it wrong?
I think Greg is right that there was a bias in favor of administrative adjudication, and also an ignorance, I think, on the part of the circuit judges about what really goes on in those proceedings. And I'll get to that in a second. But, for example, Richard Berman, a highly respected Southern District of New York judge, had actually ruled that the process was likely unconstitutional. There was a judge in the Northern District of Georgia who ruled in two separate cases that the way the Supreme Court ultimately ruled. And the big mystery to me, having argued Thunder Basin in 3 circuits and, probably briefed it, I think, more than anyone had, it is an incomprehensible doctrine, but it's also inconsistent with a case called Free Enterprise Fund, which predated all of these decisions going the other way. And what Free Enterprise Fund said is that the very same statute, 78Y, does not strip jurisdiction from the district courts either expressly or impliedly. And yet, that's how 5 circuits, as Greg noted, went before we challenged in both Ray Lucia's case and Michelle's case. By the time we got to the en banc, it was 7 decisions against us.
Right. So when you were very first researching this case and just jumping into the research, and you read that line from Free Enterprise Fund, did you think, well, this question's already been decided?
Well, there had been enough bad decisions by the time we entered the stage for Ray Lucia and Michelle. I knew it was an uphill battle. It shouldn't have been, but it was. I like to hope that Justice Gorsuch's concurrence has pulled the plug on and drained Thunder Basin.
Well, I'm going to get to that question here in a second. I want to give a little bit of credit to Judge McBride, who was the district judge in this case, even though he found the late Judge McBride, even though he found that there wasn't subject matter jurisdiction here, he did write a decision that was skeptical about the lack of jurisdiction, said he felt like he had to rule that way. But he did not think that Michelle should have to be put through another futile administrative process. And he said that, and I think that might have gotten the Fifth Circuit's attention a little bit.
That's true. I agree. And I also think the Fifth Circuit, I think the moment I felt I connected best with those 16 judges was when I went through a litany of how long Ray Lucia had been in the process, 6 years, Michelle Cochran, 4.5 or 5 years, a guy named David Bandemir, 10 years, Christopher Gibson, I think it was 6, and that was also briefed to the Supreme Court by an amicus when we were trying to get the cases heard together. And I think when you bring to appellate judges' attention just how dilatory, costly, and due process-less the administrative proceedings are, I think finally we got their attention.
Greg, you mentioned that this was a unanimous decision. Does that matter?
I think it does. I was sort of reminded of the line from Justice Kagan, we're all textualists now, and you can sort of, debate what kind of textualists. But I think the fact that it's unanimous, does sort of reflect that even though all the justices aren't in the same place on skepticism of the administrative state, the court as a whole has moved in a position where it's more common to be skeptical of the administrative state. I don't think this would have been a unanimous decision several years ago. In fact, one of the more recent decisions in which the Thunder Basin issue came up, a case called Elgin, was 6-3, and I think at 6-3, and I think it was, Peggy will remember, but Justice Kagan, Justice Alito, and maybe Justice Ginsburg, who dissented in that case. So it wasn't the typical lineup, but even in that case, you had 6 justices saying that jurisdiction had been impliedly stripped. And even in this case, although I think this case moves the baseline considerably, you have a court saying, well, we're not saying we want to unleash the floodgates on interlocutory review. And you could see that from the oral argument, that there was still some discomfort with the notion that everybody would go to district court and bypass the administrative agencies. But
more in the oral argument than in the decision, though.
The decision, that's right.
Yeah.
But I don't, the more every time I reread the decision again, the more I see what a resounding defeat it was for the government, and the view that individuals had to be dragged through this process before they could go to a federal court to vindicate their constitutional rights.
Similar question to you, Peggy. Does it matter that Justice Kagan is the one who authored the decision?
Well, she's certainly a scholar of administrative law. And she wrote as she often does, a very crisp opinion. It's short, it's to the point, which was also the case in Lucia, which was a necessary predicate, I believe, for this case.
Justice Kagan wrote it?
Yes, yeah. And so I think it carries certain authority that she, as the sort of resident specialist in this area, is prepared to rule in that fashion. I think she probably favored keeping Thunder Basin alive in ways that perhaps a different alignment, if someone else had written the decision, such as Justice Gorsuch, she might have had a little bit different alignment. But it's a great outcome and a great advance for people who have been charged by administrative agencies.
To be sure. The last question along these lines, does it matter that the decision implicates multiple agencies? Obviously, the Axon case involved the FTC, the Cochran case involved the Securities and Exchange Commission, but the question was really the same in both cases, whether there's subject matter jurisdiction in the courts. You don't often see 2 cases brought together with one decision like this.
Yeah, I think it does, and I think it was very important and helpful that the court granted review in the Cochran case as well as the Axon case, and one of the, it's Mark and Peggy know, one of the sort of interesting procedural wrangles that we faced along the way was that the government initially had asked the Supreme Court only to hold the Cochran case for Axon, and we said, I'm thinking it over. Usually, as a respondent, you don't urge the Supreme Court to grant review in the case, but we said, our fear was that even if the government lost Axon and the FTC, they would come back and find some narrow interpretation of the SEC Act and say, maybe it's different, and there's still judicial review had been stripped in that class of cases, and we thought it was better to put that case up. And so I think from that perspective, getting the resounding victory in Cochran was important. But even more than that, I think the Axon case involved a corporation, and the fact that the Cochran case involved an individual, which not only is it the case of individuals where this issue comes up most frequently, hundreds if not thousands of individuals trapped in this situation, but also I think the experience that the individual faces in this situation is so powerful, and you could see it most clearly in Justice Gorsuch's opinion, where he went through in detail Michelle Cochran's story.
Ordeal, maybe.
Ordeal,
yeah.
Which Peggy and Mark have been litigating with, and that story essentially comes from their briefs, and ultimately says not everyone has the perseverance of Michelle Cochran and Axon in that case, but I just think that that's such a powerful message that resonated no doubt with the court, and that ultimately will inform the way that people look at this issue and the decision in Cochran.
So I want to ask a little bit about the Thunder Basin factors, because I think that someone who wasn't deeply familiar with this area of the law might look at the decision and say, oh, well, the Thunder Basin factors were reaffirmed here by this decision or by Justice Kagan's opinion. But let me put that to you, Peggy. Were the Thunder Basin factors reaffirmed, or were they weakened by this decision, do you think?
Well, certainly they were properly applied. And that was one thing, if you want to see a very interesting earlier episode of Lunch and Law, we did one with Judge Droney, who was the first dissenter. And one of the things he was prepared to say was, well, courts say they're applying the Thunder Basin factors, but they're really not. Because you simply cannot designate a review that takes place 6 years after an unconstitutional proceeding as meaningful. I mean, that's so obvious as to be almost insulting to have to argue. It's certainly, whether the proceeding is constitutional, is certainly collateral to any specific matter to be decided in that proceeding. And finally, and this word never gets enough attention, so I'm going to really stress it right now. The third thing has to do with agency expertise. But what Free Enterprise Fund says, agency competence and expertise. So in 2010, the Supreme Court said this kind of decision-making was beyond an agency's competence, and it is just beyond my ken why that word competence kept getting dropped, and they kept talking about agency expertise. Incidentally, it also does not involve agency expertise. But I think that those...
Certainly not in the subject matter of the agency at all.
So they were certainly properly applied, but I do think that Thunder Basin, as a sort of judge-made doctrine that got misapplied in such a dramatic fashion for so many years, it's somewhat weakened, and at least I hope it is. And I think that people should view with caution any kind of judge-made multi-step doctrine, because as someone who's briefed this issue probably more than anyone I can imagine, it is so malleable and so easy. One of the questions that came up in an oral argument from Justice Alito, I believe, was, well, what happens if one of the factors is satisfied but not the other two, or which one counts more? Nobody knows.
Yeah.
And in fact, the lower courts were sometimes saying, well, we think this one's more important, or we admit this other one doesn't argue in favor of administrative adjudication, but we're going to let the other two ones outweigh it. No, this is all made up by people, who are incidentally clearing their own dockets at the time they're making the decision to send people back into that multi-year proceeding.
What do you make of that, Greg? So there was a lot more discussion of that in oral argument than there was in the decision. Justice Kagan gives us almost no answers to the question Peggy poses about, well, what if it's one factor goes one way and the other factor cuts the other way?
Right.
Why do you think that the court didn't give any more guidance on those sorts of questions that came up for quite a long period of time in your discussion with the justices?
Sure. Well, I mean, first of all, I definitely agree with Peggy. I mean, I think this is unquestionably a step forward in terms of how the court views Thunder Basin, and I think, scales back the unduly restrictive interpretation that lower courts had adopted. And, hopefully, just as lower courts may have taken their cues from Thunder Basin and Elgin before, which had come out the other way, they'll start to see the law a little bit differently in light of this decision. And so, a more generous application of its factor towards judicial review, I think, is a big positive. I also think that Justice Gorsuch's concurring opinion, where he concurred in the judgment, is very significant as well, because although the court ultimately did not adopt Justice Gorsuch's view that the court should dispense with the judge-made Thunder Basin factors and just look at this through the lens of interpreting what Congress has said about jurisdiction and the relevant statutes. Justice, and this was, as you mentioned, this was a big question that sort of ran throughout the oral arguments, is methodologically how should the court pursue this. But Justice Gorsuch lays this out in such what I think clear and compelling detail that I think that even if it doesn't result in the ultimate scuttling of the Thunder Basin doctrine, and one could hope, I think it is going to weaken its application. As courts has sort of laid bare the problems with this doctrine.
Yeah, I share your view of Justice Gorsuch's concurrence in the judgment, but as I was reading it at the same time, I thought, gosh, if this had been the majority opinion, would this have been a less watershed opinion? And I think in some ways it would have been.
Yeah, no, I think that's a good point.
Do the factors have equal weight, the Thunder Basin factors? Do we know the answer to that?
Some of the five SEC ALJ cases did say the meaningful judicial review had more weight than others. I don't know of any court other than perhaps the majority in the Second Circuit that found all three factors in favor. So what you have to realize is that the majority of the lower circuit courts that looked at this admitted that at least one, sometimes two factors were in favor of allowing people to go to district court, and yet, by some
alchemy.
Yeah, exactly. Magic words or whatever. They were able to say, well, meaningful judicial review. And there was an excellent law review article that had not only good textual arguments, but also good policy arguments of why eventual judicial review is not meaningful judicial review. And that was cited a great deal in our briefing. And I think certainly the majority opinion got that message.
So, Greg, how wide is the spigot open now for challenges to administrative agencies in federal district court? The court could have set some boundaries in this decision, but they really didn't, or at least not not explicitly.
No, they didn't address that at all, and that was one of the issues that had been touched upon in the briefs is, we talk about structural constitutional claims generally, but what are we really, what's really at issue in this case? And the court had some concern at oral argument about, going too far and opening up the spigot. So I think, obviously the insulation from removal type claims at issue in Cochran and Axon, I think, you can imagine appointments clause, due process type claims to the structural nature of the proceedings. I think that maybe one of the big questions that will come out of this is challenges to the lack of a jury trial that'll be on. So, and non-delegation issues. So I don't, and as we've seen over time, particularly in recent years, as the court has begun to re-examine some of these things, I don't think there'll be a shortage of, constitutional claims, creative thinking by groups like NCLA and others. And so this will be, I think, the next frontier is sort of thinking about the boundaries of what this decision allows. But even with respect to those claims that don't fall squarely within it, I think that just brings us back to the question we talked about earlier, is application of Thunder Basin and maybe a willingness to go even further in re-examining this area.
Well, thanks to both of you for making NCLA's job easier going forward. I definitely think that we'll have fewer jurisdictional fights. But Peggy, do you have any thoughts on that? I know Greg spoke on a panel at the Federalist Society earlier this week with Professor Richard Pierce, I think it was. Yeah. And he said that there were 8 kinds of challenges that are going to reach the Supreme Court in the near future, but then he didn't say what those 8 were. So I was trying to kind of map them out on the back of a napkin. I got up to 6 or 7, so I don't know if you have thoughts on that.
Yeah, well, actually, I copied your napkin.
Oh, okay.
So as Greg said, removal protections, jury trial rights, Humphrey's executor, it comes up in these contexts as well, Chevron deference. If the agency is like the CFPB and it has what someone could claim is unconstitutional funding, I think that is a structural question that certainly could go and must go to a federal district court. There's more than one kind of non-delegation argument. There's the kind that's in jarcossy, which is about the decision whether to proceed administratively or through jury trials. But I think that also just the combination of adjudicative and executive power in one agency is another brand of that, and I think that's definitely up for grabs. And maybe
whether you can delegate it to a PCAOB or a FINRA or some of these other quasi-governmental entities.
Which is even more troubling in my view, and is something that has to be decided in a federal court. And then finally, my colleague Russ Ryan reminded me that there was a decision, I don't remember its name, in which it was decided that having as your first court of appeal in the administrative process the very commission that voted to prosecute you in the first place was at one point held to be okay. I think that there will be efforts to overturn that decision because it is, in fact, such a troubling thing that the agency is asking to set aside its own decision to prosecute someone in the first place. And the structural bias and the asymmetry there is just so obvious that I expect that would be one of the 8 as well.
Don't quote me on it. I think that case might be Withrow, but I can't remember.
Yeah, I think that's right.
For sure.
Yeah.
What's the significance, Greg, of pronouncing a hearing in front of a judge with undue removal protections, which was the underlying problem allegedly here with the SEC? What's the significance of pronouncing that a here and now injury, which is something that Justice Kagan said, and really referring back to seal law or some of the other cases?
Exactly. I mean, I think that is important. I mean, this is something the court had first said in the Celia Law case a couple of years ago, and I think really sort of underscores the real world impact of what we might otherwise think of as these sort of academic, structural, constitutional debates. That this isn't just about theories of constitutional law. It's about what these constitutional issues and defects, the impacts that they have on actual individuals or corporations in the real world. And the court unanimously recognized that in this case. And if there was ever a case to sort of see those real world impacts, it was Michelle Cochran's, as Justice Gorsuch laid out in detail in his separate opinion.
How would you define a here and now injury for a non-lawyer? What does that mean when the court says that?
Well, I think what's important about it is it can't be this type of injury, being subjected to this administrative process can't really be remedied later. Once you've been through it, you don't really get your life back. You don't get those few years of your life back. So that's part of it. But the other part of it is just that it is just what it says. It's you're incurring an injury right now. It's real. It's something you're feeling and suffering, and it's concrete, which has importance obviously for Article III considerations.
I think I'll speak for myself. I was concerned after the Collins decision, Peggy, that the court might have reached a point where it was going to say, well, if you have an appointments clause problem like you had in Lucia, then we'll give you a remedy. But if it's just a removal problem, then there won't be a remedy. We're just not going to worry about that. By calling it a here and now injury, I think that's off the table. I think that there is a remedy. It's just an ex ante remedy instead of an ex post remedy.
Yes, and indeed, the dual or sometimes more than that layers of protection are statutory. So it's not something that a court should fix. I mean, and what do they do? Decide to set aside the Merit Protection System Protection Board and their removal protections? I mean, that would affect all agencies. So you really can't ask for severance in any kind of a rational way. And the SEC had argued that. And in our papers, we described that as a bad habit that courts had of acting like they were on-call plastic surgeons to do the necessary surgery to save Congress from unconstitutional schemes. And I hope that courts won't do that. They will recognize that this is something that must be fixed by Congress, but that Americans should not have to undergo.
So this wasn't the first effort that NCLA had made to try to get this question in front of the justices. Greg, you were lead on the cert petition that we filed in the Gibson case, and Peggy, you were Christopher's attorney here at NCLA, working hard on that brief as well. Why do you think the court wasn't interested in the case when we presented the cert petition in Gibson, Greg?
Yeah, the easy answer is there's no conflict of authority in the circuits, and it was frustrating and very disappointing because I thought that this is a case where if ever there was a situation where the Supreme Court needed to step in the absence of a conflict, this was it. You had one circuit after another, going the same way, clearly going off track in a way that impacted, and thousands of individuals' lives. We had powerful amicus support by folks who had been through this in a number of these other cases, and the court denied cert, and that's because it almost always demands a circuit conflict, and that's why creating the circuit conflict here was really the key that unlocked everything. It was the critical step, because without that, we probably would still be fighting this in the lower courts and frankly losing it.
Yeah, if I remember the chronology correctly here, Peggy, Axon had not been granted cert at the point in time when you won the en banc in the Fifth Circuit in the Cochran case.
That's correct, and very quickly Axon was given cert, and we had supported Axon in its efforts to get to the Supreme Court as well. Personally, I think it was a good...
Back in the Ninth Circuit, I think.
Exactly.
Yeah.
I think it was a good thing that both cases went up there together, and partially because if it had only been Michelle's kind of case, where it's these individuals, I think there might have been something in the back of the court's mind about, well, what if these corporations are out there really violating the securities laws or the Federal Trade Commission laws in major ways? Do we want to preserve that? But what you saw in the Axon case was an incredible abuse of process by the FTC, which, by the way, wins 100% of the time in their administrative cases over the last 25 years. But they were objecting to a merger in Axon's case. And
it was already consummated like a year and a half earlier.
And Axon agreed to undo the merger. And then they wanted to order them to turn over their own intellectual property to what would then now be a competitor. An outrageous abuse of power that the commission had no authority to order, or no court had an authority to order. So I think when you see that abusive process by one agency against a fairly large corporation and then see what it does to individuals, you've got a pretty complete picture before the Supreme Court about the deprivations of due process and other constitutional deficits in these proceedings that ought to bring great concern to the court.
Yeah, I certainly agree. One of the questions that I've heard people ask in the wake of the Cochran decision, Greg, is what does this mean for preliminary injunctions going forward? So is the irreparable harm prong of a preliminary injunction against an agency in the future, is that already going to be satisfied? Do you just say, well, this is a here and now injury, cite Cochran, we meet the preliminary injunction prong on irreparable harm?
Yeah, I think that's the way to argue it, and I think it's a good argument. I think we're going to have to see how that shakes out in the lower courts. There's going to be additional issues about whether district courts should stay administrative proceedings or the administrative proceedings themselves should stay. So that these are going to be some of the interesting wrinkles that'll be played out in courts across the country, I'm sure.
So you won a preliminary injunction, Peggy, in the Cochran case. We tried to get a stay, a preliminary injunction, a stay of the administrative proceedings in Cochran. We tried to get a stay in the Lucia case in the Ninth Circuit, and if I remember correctly, we didn't have no luck with that.
Yeah.
So do you have a thought on going forward? Are stays going to be easier to get against these administrative proceedings?
Yeah, I think so. I mean, you're still going to have the likelihood of success on the merit prong of an injunction, but I think that that's manageable, and especially when you talk about these structural constitutional claims, I'm not too worried that people will not be able to satisfy those. So yeah, I do think it is an advance forward in enjoining proceedings that are going to otherwise alter people's lives for many years without there being any effective remedy.
So we didn't get the stay in Lucia. He quickly settled the case after that. We did get the stay in the Cochran case, and she was able to prevail all the way to the Supreme Court. How important is the stay of the administrative proceedings in these kinds of cases?
Well, Justice Gorsuch talks about that in his opinion, how costly these administrative proceedings are. And there was briefing to the court, excellent briefing by our amici that showed that, as long ago as 15 years ago, the costs of defending an administrative proceedings start at about $100,000 and easily exceed $1 million. This is 15 years ago. And the data on the cost of those prolonged proceedings and the fact that they are ruinous and force people to throw in the towel, as Ray Lucia eventually had to do, because they simply cannot withstand, anywhere from 5 to 10 years of protracted litigation that isn't even real litigation addressing the real legal matters at stake. I think that got through to the court. And I think also anybody arguing, whether it be for a stay or for ruling on the merits, ought to really bring some of these issues before the court in terms of cost of these proceedings, but also anticipate the floodgates argument. I don't think the floodgates are more than a trickle in terms of the real big issues at stake here. And all you're talking about is returning the world to, say, a pre-Dodd-Frank world that we all seem to live in,
less than 15 years ago.
Exactly, and that preserves all those constitutional rights and doesn't have those biases. The other thing that Justice Gorsuch talked about in his concurrence was the fact that Michelle was before a judge who had announced that he had never ruled except in favor of the agency. And that, along with the statistical success rates, embarrassingly show a process that is biased, asymmetrical, due processless, and I could probably go on, but won't.
Sure. What do you think about that, Greg? Do you think that the floodgates will open now, or do you think that maybe agencies, knowing that folks can go to federal district court with some of these kinds of objections anyway, that they may be more circumspect in the kinds of cases that they bring in front of even their own ALJs?
Hopefully they'll be more circumspect, although I don't know that we can, assume the best of intentions in terms of how they proceed. I mean, given the success rate that agencies have before their own administrative judges, 90% or more, one could see the reasons why agencies would go that route. I do think, though, that just to sort of pick up on something that Peggy said in talking about how these cases come arise, I mean, the real heroes are people like Michelle Cochran, who are willing to sort of, stand up and fight, given the enormous, personal and professional consequences, as well as organizations like NCLA, who are willing to come in and litigate on behalf of these individuals, because the pressures that they face to throw in the towel and settle virtually everyone else are, overwhelming.
I wonder sometimes if the justices have a full appreciation for how many people are out there in the position of a Michelle Cochran. And as much as we might want to, we can't take every one of those cases. Right. We don't have enough lawyers and enough resources to represent all those folks. And I mean, kudos to Latham and Watkins and your willingness, Greg, to argue not just the Gibson case, but the Cochran case as well on a pro bono basis. I mean, this would cost tens of thousands of dollars, I assume, for someone to engage a firm like yours to take a case all the way through oral argument at the Supreme Court. Yeah, no, it's obviously it was a great thrill for us to be involved, and it's important stuff. Peggy, you were here as part of the case intake at NCLA. I mean, how often do we hear about cases where we wish we could get involved, but we just can't take them all?
It's quite frequent, and there has been an uptick in inquiries since this decision has come down. Christopher Gibson has actually filed, I think, what may be the first challenge in district court, and he has a very strong case because in his case, and this is something that came out earlier too, he was prosecuted once before an ALJ on one theory, okay, and then that decision got set aside when the Lucia decision was handed down in 2018, which held that the ALJs were not constitutionally appointed. So then he had a second hearing. Well, that time they tried a different theory out on him that was not even in the original proceedings against him. That is something a federal judge would not allow. Okay, you get a second try at this. And it's just one more example of how these administrative proceedings throw the rule book out the window. And I think the more the courts get an appreciation for that and see that judges, for example, announce they've never held except in favor of the agency, or they start coming up with new theories mid-trial, and then we had wonderful briefing about the other asymmetries. The administrative proceedings have really short time frames. So the agency could investigate you for years, and does. Very often those investigations go on from 1 to 5 years.
And that has costs as well, especially if you're having to turn over documents. And
enormous cost.
Yeah.
And then when they charge you, you have anywhere from 30 to 75 days to 120 days to put up a defense when you've had this document dump from the government, and you've got to scramble, try to defend yourself in proceedings that do not follow the rules of evidence, that allow hearsay, that allow admission of deposition testimony that the agency has taken pre-trial, at which you had no ability to cross-examine that witness. I mean, the due process deficits are shocking and enormous, and we had good briefing on that. And I think going forward, anyone challenging these things should study some of the amicus briefs that we filed in Michelle Cochran's favor that set out an astonishingly long list of due process deficits that are built into the system.
Yeah, and a shout out to the various amici that I think it was 10 different briefs, if I remember correctly, and 14 or 16 different groups that participated as amici in the case at the Supreme Court. And obviously we appreciate that. Helped, I think, the court reach the right decision. One of the things that to me is maybe the most significant aspect of this decision, Greg, is that I think as a result of the Cochran case and the Axon decision, that there will be a faster cycling through of constitutional challenges to administrative adjudication. So we've had this situation now for the last decade or more where people have been waiting 6, 7, 8, 9, 10 years going through the administrative process before they ever get to federal district court. Well, if we can eliminate or at least radically shorten that time period, then do you think the Supreme Court will decide some of these questions that are some of Richard Pierce's list of 8 questions? Will decide those more quickly going forward?
I do. I mean, I think it's a couple of things. One, it's the fast, getting to federal court faster. But the other thing is that there are going to be a lot more individuals going, right, and bringing the claims instead of people sort of dying on the vine in the agency process and giving up their cases because they have no choice. They, if they have the option to go to federal court and bring these structural constitutional claims first, presumably they will. And so I do think that will lead to the courts entertaining these claims and hopefully validating some of these claims. I mean, one of the ironies is very important case going before the Supreme Court right now is the Garre case out of the Fifth Circuit. And Garre was one of the earlier cases in which he tried to go to the district court to bring his constitutional claims. The DC Circuit shut that down, and so he therefore had to go through his administrative process, which he did, and then he petitioned for review to the Fifth Circuit, and the Fifth Circuit embraced his claims to great effect. And the government has now petitioned for certiorari in that case. It seems likely that the court will grant review in that case, so it's an opportunity to address several of those constitutional claims right off the bat.
I can't help but wonder if the SEC ruse the day that it brought charges against Michelle Cochran, Garre, and some of these other individuals over some really fairly penny-ante kind of accusations. Did you have any thoughts on that, Peggy, about the sort of faster cycling through and more people bringing these cases? Do you think that may be one of the reasons why Cochran proves to be an extremely important precedent?
Yes, certainly. If our intake just here is any measure, we have gotten many inquiries from people who have been, frustrated or worse by the administrative process. The other thing, in addition to the cost, there's an interesting fact about Michelle in that she tried to get a lawyer to represent her, and what he told her is true, that they always rule in the agency's favor, and I'll just be taking your money. And that is actually an honest lawyer. And so she had to defend that pro se. So I think, the cost of those proceedings are something that has been of great.
For our non-lawyer audience, pro se means that she argued the case herself in front of the SEC without the assistance of a lawyer. I think actually her ex-husband helped, if I remember correctly, with the argument. So imagine being in that position where you go to a lawyer won't help you, or won't take your money, tells you that it's futile, and you're left to your own devices to try to defend yourself in front of a powerful federal agency, in front of an administrative law judge employed by that agency. That's what she was up against.
And I think by lifting the veil on these proceedings, which I think we have with Michelle's case and Ray Lucia, we did a lot of briefing in those cases as well. And getting these things into the public record is so important, because I don't think that the judges really appreciated how biased these processes are. And the other problem, 98% of these cases settled, and that was discussed in all of the briefing in Cochran, and that was a big factor in Judge Droney's dissent, was that the process is so biased against people that they really have no fair chance to defend themselves. And what happens when you settle with the SEC is you are gagged. You may not talk about your proceeding or how unfair you thought it was, or whether the SEC actually had a viable case against you.
Or whether there were constitutional structural problems with the agency that shouldn't have had you in front of them in the first place.
And this is slightly off topic, because we are working very hard to get rid of the gag, but I'm not sure the Supreme Court appreciates the fact that the reason they don't know and haven't known about all of these due process deficits and the length of time people were trapped in those proceedings is directly connected with what is an outlier rule by the SEC that you have to be gagged, because no other federal agency gags you other than the CFTC following suit with the SEC. It's a wildly unconstitutional thing. It hides administrative abuses from public review and is directly contrary to the core mission of the First Amendment, which is to bring government power out into the open.
Well, I want to jump to Justice Thomas and Justice Gorsuch here in a second, but before I do, is there anything else from Kagan's majority opinion that jumped out at you, Greg, or anything else you want to mention about that we didn't get to here?
No, I mean, I think it's characteristically a very well-written opinion, and I think, again, if you were just reading this opinion and you didn't know anything about the backdrop here, you'd think, well, this is an easy case. But what's important about the decision is it basically is saying that lower courts had gotten it wrong for almost a decade, and so the fact that she marched through the factors in such a straightforward and I think compelling way is very powerful at the end of the day.
If nothing else, it's an example for the lower courts. This is how you do it.
Right. Exactly. Exactly.
How about you, Peggy? Any final thoughts on the Kagan majority opinion?
No, I mean, I think she likes to use logic, and she shows about how the timing issue is so compelling, because, again, people didn't seem to appreciate that you need to decide whether that judge who's going to rule in your case is constitutional before he rules. And it sounds so simple, but people were losing on this left and right throughout, courts presided over by, highly intelligent and experienced judges. And I think her logic was well laid out, and I think, somewhat embarrassing for the courts that had ruled in a contrary fashion.
So let's jump to Justice Thomas. So he joined the majority opinion in full, but he wrote separately. What did he say, Greg? So
he, as he often does, up the ante really in this area, and said that he questioned whether or not it was constitutional to have this sort of administrative review scheme at all, where you had to go to an administrative agency to have your life, liberty, or property adjudicated, and only could get judicial review of that determination at the back end. And he,
with deference.
With the deference that comes along with deference to the agency's fact finding and other doctrines. He said he had grave doubts about the constitutionality of that. And I think that just casts an even greater cloud over the legitimacy and constitutionality of these in-house agency proceedings that occur all the time across the country, in which individuals are subjected to fines. Michelle Cochran initially was subjected to a $22,500 fine, which is devastating for a single mother of two, and where their livelihood is on the line with professional licenses or bans, as Michelle Cochran initially got in her case. So that's really significant generally, and I think it also may bear on the jury trial question, which is one of the questions that will be undoubtedly adjudicated in the wake of Cochran and Axon.
Peggy, do you share Justice Thomas's grave doubts?
Yes.
Breaking news.
Let me make this personal. Okay, sure. I practiced law for nearly 40 years. Before I came here, I had no idea that people were going through such unconstitutional proceedings. I mean, shame on me for not studying administrative law more closely, but I didn't know that this was going on. And my jaw just kept dropping as I would interview people and understand what they had gone through. And I've litigated cases in state and federal courts for decades, and I know what a constitutional and fair trial looks like, and it doesn't look like what the FTC and the SEC has been dispensing for the last decade or more.
It looks like something more out of Charles Dickens.
Oh, it does. I mean, and it's Kafkaesque. If just to bring it back to Michelle, if she had won, on the removal thing, her prize is to go back and be retried yet a third time, and that is what, to Judge McBride's great credit, he pointed out, with some fervor, that he was deeply concerned about the fact that she would have to go through a second proceeding only to find, if she was victorious, that she would have to go back and do it a third time. That happens in regimes that we don't want to live under. It should not happen here.
Yeah, absolutely. Any other thoughts about Justice Thomas's decision? Was there anything surprising in there? I mean, he's been on this train for a while of I think having some concerns about the administrative state. He mentioned even in his I can't remember now if it was a dissent from a denial of cert or a concurrence in a denial from cert, but he wrote to raise this issue anyway in the Baldwin case, where we had filed a cert petition saying that the administrative state was that we'd reached the precipice of administrative absolutism. This was with regard to the Brand X decision, and we needed to take a step back. So he's beating that drum again, which I'm delighted to see, but is he going to have anybody else join him?
Well, very often if there's a strong dissent, and this wasn't a dissent, it's obviously a concurrence, but a concurrence stressing things separate from what was expressed in the majority opinion, you'll get a colloquy. Somebody in the majority will say, well, Justice Thomas is off on a tangent or whatever. There was none of that. There was no sense that you could predict one way or another as to whether others would join him. But Greg pointed out, and I've always been interested in the fact that the Elgin decision had a dissent by Justices Alito, Kagan, and the late Justice Ginsburg. And I'm not sure that case would be decided the same way today or the same way after Cochran. And so I think, and that was a case, I think, where Justice Gorsuch's approach would have really helped the Elgin court to realize the right way to look at that. So I'm hopeful that by, one of the points of separate opinions is they can plow new ground and turn it over and get people thinking about it. And I'm hoping both the Thomas and Gorsuch concurrences will be fruitful in that fashion.
Just let the audience know in about 5 minutes we're going to open it up to questions. So if you have a question, be thinking about that, get it formulated and ready to go. If you're joining us online, go ahead and feel free to start putting those questions in the chat, and we'll get to those in just a minute. But before we do that, I want to come to you mentioned Justice Gorsuch, Peggy. He this is a concurrence in the judgment, but not in the majority opinion. So it's 9-0 in terms of the decision in the case, 8-1 in terms of Kagan's reasoning, I guess you'd say. What is his reasoning? Why does he? Greg alluded to this earlier, but why does he take a different view here?
It's pure statutory interpretation, which I always thought was our best argument, and I always wanted that in the case, because if you look at 78Y, there's nothing in that statutory scheme that strips jurisdiction. If you look at Section 1331, it confers jurisdiction on district courts that they must reach constitutional questions that are properly brought before them. So whether you're...
I'm just going to interrupt this for our non-lawyer audience out there. This is Section 1331. That is the statute that gives federal district court jurisdiction broadly. That's not specific to agency cases, not specific to the SEC. This is federal courts can hear federal claims, right? That's the basis.
And there's no... there's a lot of law that says once that jurisdiction is conferred by that statute, they're under a duty to honor that conferral of jurisdiction. And there's nothing in the statutory scheme under 78Y that strips that. And so it's a much cleaner way. I mean, I think a layman would gather from this discussion that the three Thunder Basin factors are, sort of like, I think didn't Justice Gorsuch talked about tossing them into a blender, wasn't it? Yeah. So, something like that.
More like that, yes.
Yes. Yeah, but I mean, it's just sort of juggling mush, and I think that I hope that Justice Gorsuch's approach of the plain statutory interpretation will have a much longer life, because it is not fair to litigants to go into a process and have no idea where they're going to end up or with what rights or abilities to defend themselves.
Greg, you alluded to this earlier, but Justice Gorsuch walked through the ordeal that Michelle Cochran went through, and there was a little comment there where he noted that the majority opinion hadn't mentioned any of that. I guess, is there any significance to that aside, but maybe more importantly, why do you think he took the time to go through Michelle's ordeal, and maybe why do you think the majority opinion didn't do that? Is it unusual? Is it maybe because there were two different cases here, they just didn't want to get too complicated with who shot John sorts of questions?
I think that might be part of it, and Justice Gorsuch, I think had maybe 3 pages of walking through Michelle's ordeal. I mean, I think the other part of it is maybe to Justice Gorsuch's effort to lay bare the fundamental problem with the whole, Thunder Basin regime. And although, I think that as we discussed, the majority opinion takes a significant step to scaling that back, it does leave the regime in place. And I think, laying bare the real world problems with that approach is pretty devastating. And Justice Gorsuch talked about the problems not only for individuals, but also for lower courts that were left with this, mushy 3-factor test, and obviously not knowing how to apply that test given the results that had happened. And he took it, even looked at it from a perspective of separation of powers. I mean, he questioned at the outset, what authority courts had to sort of impliedly strip jurisdiction that Congress had explicitly given to begin with. And so I think it's a really important marker. I think if in the wake of Cochran we see the court either not relying on Thunder Basin as much or applying the factors and holding the jurisdiction exists, then maybe that's okay. But if you see sort of what happened before Cochran, a strict application of Thunder Basin that is stripping jurisdiction, then I think a lot of people will be taking a serious look at Justice Gorsuch's opinion, because it is one of the, I think, more clearer, more compelling cases for why one of the court's decisions doesn't work that I've seen in a while.
Yeah. Before we jump to questions, Peggy, any final thoughts or takeaways or predictions about what's going to happen as a result of this?
Well, I'd like to focus on just one more aspect of Justice Gorsuch's concurrence, Sure. And that is that he has a footnote in there. He not only talks about what Michelle went through, but the overwhelming pressure to settle and how unsatisfying that is, because people really don't get a chance to defend themselves. But in footnote 4, he points out that these consent settlements very often extract from targets things that that the agency would never win in litigation. For example, hand over your intellectual property, as Axon was asked to do. For example, in the SEC context, we're going to gag you for life. And I was overjoyed to see that footnote.
That might be cited in the future?
It's let's say it's a macro on my computer, and I'm just going to hit the button and put it in the appropriate briefs where it belongs.
How about you, Greg? Any final takeaways before we jump to questions?
I mean, I'm grateful to the court. I think it's a great decision. It was a very professionally fulfilling process to go through, and it's always, it doesn't always work out this way. So you have to appreciate it when the court gets it right.
Yeah, absolutely. and I guess maybe my final thought before questions would just be that I want to give kudos to Axon as well, and Pam Peterson, the general counsel, because they stuck it out too.
Yep.
Most companies fold when they're presented with these sorts of challenges, and they didn't, and they stuck it out as well. So obviously we know Michelle Cochran's a hero, but I am very happy with them, and also your counterpart Paul Clement, who did the oral argument for them, did a fine job at the court.
He did great
as well. So let's go ahead and throw it open to questions. Looks like we have one in the back.
So I wanted to get a bit into the weeds of Justice Gorsuch's opinion because, as Peggy knows, there's a bit of a, small poison pill in there. And so just wondering how far Congress can pick up on it and take it. So Justice Gorsuch, in his concurrent opinion, says, Congress knows how to give jurisdiction, see Section 1331, and Congress knows how to withdraw jurisdiction. He cites to a statute governing FDIC. And as Peggy knows, because she's one of the co-authors of the amicus brief we just did in the Fifth Circuit, we had to deal with that. And so the question is basically this. Is Congress likely, in the wake of this decision, to say, fine, we will rewrite Section 78Y explicitly withdrawing jurisdiction, and every time we have new agency or new agency reg, we will simply say no jurisdiction explicitly, and if so, kind of how do future Michelle Cochrans deal with it?
Yeah, I mean, I think certainly Congress could do that, and that's, one of the pros or cons of putting the power back in the hands of the legislature to make these determinations, right? I mean, I guess, although Congress ends up having a lot of power in the wake of financial crisis and the like, we know, I mean, I guess I'm not as, I don't see that as necessarily likely, both in the sense that would be politically popular, but also I don't know that Congress would take that up specifically.
Yeah, is there a constituency for that?
Right, exactly.
Well, and I would add that Michelle Cochran and pretty much every other client we've had would be able to testify before Congress about what a disastrous thing that would be to do,
right.
and openly say, you're taking our due process of rights away from us. That's the problem with the judge-made Thunder Basin doctrine. No citizen was able to say, you judges concoct a three-part test that's going to take my constitutional rights away from me. They had no input into that. And certainly if Congress starts to do that, I can think of a long list of people I would call on to object to that.
Yeah, that's a great point about judge-made doctrine. Over here, John.
Yeah, 2 points and then a question. One thing this also does is that it starts it in the district court, and any facts found will be found in the district court and not in the agencies. And I think one of the horrible things about this is that the courts have to defer, actually just, unless it's a complete botch, they have to accept the facts found in the agency, and the agency is set up to find facts for the agency. And the second point is, so I think that's a very powerful part of this case, is that you're starting the district court, facts will be found under the federal rules of evidence and not under whatever, monkey shines they do in the administrative process. The second point is that I think one of the reasons they didn't get into the facts of each side in the SEC and the FTC is one of the things is we had in the SEC case a judge who like twirls his black mustache in the administrative agency and says, "I never ruled for you, ha ha." But in the FTC action, there's only one FTC administrative law judge, and in his whole career, every time he rules against the FTC, the commission reverses him and says you were wrong, and only if he rules for them. And the guy keeps ruling like he was a real judge. And I don't know how he keeps it up, but he does, and he's overturned. So it doesn't matter what people you put in those slots. The process has created these horrible outcomes that are not due process and not fair. But my question for both of you is, in Kagan's opinion, she says, "Oh, these challenges are existential questions and threats to the existence of these agencies." I mean, I think that's kind of burying the lead. She's like expecting something now because she didn't have to write that. That was incredible that she wrote that, I thought. What do you think about that?
I absolutely, and I put that into my statement when we won the case. That opening was stunning. She said that they were fundamental, even existential, going to the very existence of the agency. I think she's right. I think that is where litigants should try to take future cases. And as you say, she didn't have to say that, but I'm sure glad she did.
Yeah, it's interesting. I mean, I agree with that. I mean, you could sort of read that statement in a couple of different ways. One, I think it underscores the importance of these questions. And two, from her perspective, it might have been an attempt to sort of limit the sorts of issues that would fall into it. But I think I like Peggy's interpretation better.
Well, I was wondering that too, because she used the word extraordinary at one point too, that these sorts of extraordinary claims can be in federal district court. I can see a judge in the future who doesn't want to find subject matter jurisdiction saying, well, this isn't an extraordinary claim. So we'll have to see how that pans out. I think there was a question over here.
We've talked a lot about what the practical effect is, say, for enforcement targets. What's the practical effect for the agencies? I know after Lucia, there was an appreciable drop of cases brought before the ALJs. Is there a sense that the agencies are just going to bring these in court now, or do you think they're just going to keep doing what they were doing and, fight off people as they can?
Well, you pointed out that there was a distinct fall off in the number of cases brought before the ALJs after Lucia, and our colleague Russ Ryan wrote about that.
And a delay in the appeals to the commission as well.
Well, exactly. Actually, the administrative process seems to be in a kind of paralysis right now, and we have brought a recent action about that in a case on behalf of a client named Marion Young, and I recommend her mandamus petition to your reading, but what it shows is
also in Texas for some reason.
Yeah, an agency that seems paralyzed, and I don't know whether it is that it's had so many losses at the Supreme Court recently, whether
5 out of the last 6, I think.
One of the shocking things that happened that we didn't even get into was at the time Michelle's case was at the Supreme Court. There was a filing by the SEC that there was a control deficiency and that enforcement staff had accessed the administrative law judge files. That was filed in the U.S. Supreme Court in Michelle Cochran's case, and also filed in the Fifth Circuit in George Jarkis's case. That's very deeply concerning.
That might be existential for the agency.
Well, we filed a prompt FOIA action, and now over a year later, we have nothing by way of disclosure of what went on from the agency. We have sued them in D.C. District Court, still have nothing. And so it makes you wonder whether the agency is aware that there have been enough instances of things like the control deficiency, things like in the case of the FTC, where they're always overruling the ALJ, even when he tries to issue an honest ruling. Enough of the SEC judges who not only say, I always rule in favor of the agency, but there's been witness intimidation that was documented in the Lucia case, where he was not able to bring his witnesses before the court because the SEC served them with subpoenas demanding that they produce 5 years of their financial records before testifying. That is witness intimidation that could never go on in a district court. So maybe the SEC and the agencies are concerned that they're in a process that has so many problems that they don't really want to bring them to a point that they would then come to a circuit court's attention.
Yeah, well, they certainly seem to be slow learners. Were there any questions from the online audience?
Yes, there were. So Stacy says, I'm curious why the exhaust administrative remedies language didn't appear anywhere in the court's opinion. That's the language I'm most familiar with, she says, so I was surprised it was never used even once. Is that an issue here?
I mean, you could think of Thunder Basin as essentially an exhaustion type doctrine that you have to go to through the administrative proceeding first before you can get to federal court.
Unless you
right.
meet these three factors.
Right,
Yeah.
exactly. But given the way that they came out, and given that there's sort of a resounding affirmance of the right to go to federal district court first, then maybe that's less surprising that language isn't in there.
So we have another question from Rodney, who says that he was a victim of one of these SEC no admit, no deny gag orders, and he is very excited to know, when will the ruling on gag orders being unconstitutional be expected from the Supreme Court? He has a very personal stake in this.
He and many others. I'm teeing up something in the Fifth Circuit. We have if that goes well, we will have a circuit split, and we had Floyd Abrams lead our cert petition in the Second Circuit petition, who did it with great skill and acuity. His daughter, who's a Southern District New York judge, issued what we call an opinion dubitante, where she had a consent in front of her and asked the SEC to explain why such a prior restraint would be constitutional. Now, she was a district judge, so she had to follow the precedent of her circuit, but she did so with a very loud dissenting voice. So I think...
And she had a humorous comment about her dad in there.
Exactly.
As well.
And he did not know she was doing this. So, we're making slow progress. The real problem is that courts have been doing this for 50 years. It's very difficult to get them to admit they've been gagging people unconstitutionally for 5 decades.
So we one more online question. It's about Greg having said something earlier about creating a circuit conflict. So Graham wants to know, if everyone is getting it wrong, if all the courts are going in one direction and it's the wrong direction, what are the things that NCLA and its allies do to create a conflict? How does that even happen, he asks.
Yeah, so one of the things we do to try to create a conflict is we look to see if there's maybe a circuit that might not have addressed that question yet. So if if there's a circuit that already has addressed that question, then if you go to a district court in that circuit, they're going to be bound by the precedent in that circuit. So you want to try to break new ground somewhere in a different circuit, in a district court that sits in a circuit that hasn't already ruled on that question. So that's the strategy to try to create a circuit split. But as Greg alluded to, it's very hard to get the Supreme Court to take cases unless the government is asked. I mean, I'm sure when you were the Solicitor General, you got them to take some cases that there weren't circuit splits on. Right. But when you don't have that advantage, it's difficult. I remember one case from when I was at my previous employer at the Washington Legal Foundation. We were the only amicus brief filed in support of cert in a case called Dark Cherokee. And the court ultimately granted cert, and our argument was 11 circuits have gone the wrong way on this issue. There aren't really any left. If you don't grant it now and fix the problem, there won't be another case that comes up to you. And I guess that was compelling because the court did grant cert and reversed all 11 circuits in that case. But I don't know if either one of you has a response to that sort of how to create a circuit split.
Well, you try to also choose a circuit where you think the judges, especially the circuit judges, might be open and willing to reach a different conclusion. Some circuits are very likely to just sort of follow in lockstep with the other circuits. Other circuits have more willingness, I think, to take a fresh look at things. So that's part of the calculus, is to choose a case in the right circuit where you think you might get some appellate judges willing to say, no, we look at it a different way.
Well, I want to, on behalf of the New Civil Liberties Alliance and our esteemed panel, I'd like to thank the audience for joining this Lunch and Law program on This Is What a Win Looks Like. The Supreme Court confirms the right to challenge agencies in court. Would all of you join me in thanking our panel? Please be sure to join us for more NCLA Lunch and Law events upcoming in May and June, including events discussing ESG policies, state-sponsored censorship, and I'm going to just go out on a limb here, probably the Supreme Court's decision in the student loan debt cancellation case. So, thanks very much.